We're delighted that the Supreme Court has unanimously dismissed the government's appeal and confirmed that the regulations under which most of the Back to Work schemes were initially created were unlawful. The court upheld the findings that Ian Duncan Smith acted beyond the powers given to him by Parliament by failing to provide any detail about various schemes in the regulations, and that in any event the required notice provisions had not been complied with. Shortly after lodging his appeal, Ian Duncan Smith rushed emergency legislation through Parliament, which retrospectively amended the law. This effectively overturned the Court of Appeal's judgment and shamefully rendered much of his own appeal proceedings academic. Indeed, the Supreme Court was moved to note that the government has rather unattractively taken up court time and public money seeking to establish something it has already sought to remedy in Parliament. We have already issued judicial review proceedings challenging the validity of that retrospective legislation, which, following today, we will seek to expedite. It is also, though, important to note that the judgment has real practical implications. In addressing one of our arguments, the court found for the first time that the government has a duty as a matter of fairness to provide from the outset enough information to job seekers about a given scheme to enable them to make informed and meaningful representations. A failure to provide that information is likely to make it unlawful for the DWP to require people to participate on a given scheme or dock their benefits if they fail to do so. The court found that on the facts of this case, the Secretary of State did not provide our clients with adequate information. For Jamie Wilson, who was stripped of his benefits for 6 months, that means that notwithstanding the retrospective legislation, we will now seek repayment of his benefits on that basis. We know that, like Jamie and Cait, hundreds of thousands of other job seekers have not been and continue not to be provided with adequate information about the dizzying array of schemes. Following today's judgment, any such job seekers can object to sanctions that have been imposed and seek the repayment of their benefits. It is staggering that Ian Duncan Smith has found himself in this position even after fast-tracking emergency retrospective legislation through Parliament specifically designed to prevent the repayment of benefits. We intend to work with advice organisations to ensure that following this ruling, affected individuals have the right information and assistance. This case has exposed an utterly shambolic system where individuals are routinely being stripped of their subsistence level benefits after receiving inadequate and inaccurate information. Ian Duncan Smith has sought to brand our clients as job snobs, but in reality all they have been seeking is a system that is fair and transparent.